Hello, everybody. Welcome. It is Tuesday, March 11th, 11 a.m. Central, noon Eastern. What a treat we are in store for today, everybody. Thank you so much for joining us on Facebook, YouTube, X, Instagram, and Rumble. I think all of our platforms are live now. So thank you for joining. Please share this. Here in Illinois, we have such a wonderful opportunity to hear from a brilliant legal mind who's going to give us so much information on all the things: Title IX, case law and parental rights, and, quote, gender identity, President Trump's executive orders. Sarah Parshall Perry is a senior legal fellow. She joins us from the Heritage Foundation. I have to tell you, anytime I've had the pleasure of being an attendee at the panels that talk about case law, that talk about legal insight on all of these issues affecting parental rights, gender identity, all of the things that, many of you here in Illinois are very concerned about affecting your children, particularly in education, but also parental rights in general. I am always so impressed by Sarah's insight, and I find myself taking copious notes. So lucky for you, this is going to be recorded, and it will be shared across all of our platforms later, so you can go back, check out all of the things that we cover. And of course, Sarah is very well known for her legal insight that has been printed in publications. So we have several articles that we're going to highlight today, and we're going to have them linked for you at our blog and across our platforms. So Sarah, welcome to, let me get you on here. Welcome to the Awake Illinois Livestream episode 20. Thank you so much for your time today.
Thank you for having me. I'm really looking forward to sharing with you.
Thank you. So you are a mother of three. You are a legal fellow, senior legal fellow with Heritage Foundation at the Edwin Meese III Center for Legal and Judicial Studies. Why don't you give us just, top 3 bullet points of your career up to this point, and we'll delve into these topics.
Well, I actually got my start, I want to say 27 years ago, doing commercial litigation and employment discrimination law. And my employment discrimination law expertise was really the springboard for working in civil rights and civil liberties generally. And I spent actually 6 years in-house as in-house counsel at an advertising agency handling their licenses, contract, and employment discrimination claims. Then stayed home, as many of us often do, with 3 children in 10 years, and spent some time raising them through those formative years before they were out the door to school. And then re-entered public service and public life as a senior legal fellow for education reform at the Family Research Council. I went then into the Trump administration at the Department of Education, enforcing all of the laws that we are now seeing a great deal about: Title VI of the Civil Rights Act, Title IX that we're going to talk about today of the education amendments. And after a year there enforcing civil rights and making sure that they were applied equally, regardless of sex or race, I then joined the Heritage Foundation 4 years ago as their senior legal fellow, specializing in just these issues, specifically the intersection of civil rights, civil liberties, and American education.
Amazing. And so, as I said, everybody, you're joining us. Please share this. Sarah is going to share with us so much information. I learn so much from her anytime she presents. So please share this across your social media. We're across all these different platforms. And Sarah, we're so grateful for your time today to really delve into this. You get it from all angles. You understand it as a mom. You understand it as an advocate, as a lawyer, and all of your legal brilliance. So thank you so much again for being here. So we're gonna delve into this, you guys. And we have Sarah's bio and all of her articles again linked, so you can take a look at this later and go back to it. We're going to start with Title IX. So a lot of people in Illinois, they hear about, boys playing on girls' sports. They have watched the executive order signed by President Trump. I personally had many friends there with their daughters and their jerseys at the White House. It was a very powerful and poignant moment. But some people still are very unclear as to the origins of Title IX. They don't really, I think, understand how important this protection is for their children, for their students. So why don't you give us sort of the bare bones basics on Title IX, and then we can delve into some of the most recent developments with it.
Yeah, thank you so much for that, Shannon, because I have to tell you, in order to understand where we are in the present age, we really have to take a trip down memory lane into the history books. Title IX of the Education Amendments of 1972 is perhaps one of the shortest federal statutes in modern civil rights law. It's only 37 words long, and it simply prohibits sex discrimination in any federally funded education program. Now, of course, it has regulations that put essentially teeth and machinery into the operation of Title IX, and those were passed in subsequent years in 1975, again in 1978, and then in 1987. But at bottom, it simply protects boys and girls' opportunity in any educational program that receives so much as $1 of federal funding. So you think, of course, well, I go to a private school, my child goes to a private school or a charter school. If your child goes to an institution that accepts so much as $1, and that is often things like using, for example, lunch programs, federally funded lunch programs for disadvantaged students, or your daughter goes to a college and she was actually funded by a Pell Grant or a student loan. If your son goes to a charter school or a private school that accepts tuition, federally funded tuition repayment programs as part of federal loans, all of these subject those schools to Title IX requirements. So it is safe to say that the majority of schools, private, public, charter school, graduate school, high school, K through 12, preschool, are funded by the government to one extent or another. And that means that just about every parent, every interested person who's listening to today's webinar is going to know a child or have a child in a federally funded education program. It was a very simple statute. It was considered the crowning achievement of the women's liberation movement, who fought for other anti-discrimination provisions, but there was nothing preventing sex discrimination in education. And really what it did was allow things like college and graduate school to become possible for women. It allowed female-only scholarships and membership societies. It allowed for scholastic athletics. And in fact, there was a case in 1971 out of Connecticut where a young woman sued her school for failing to offer an opportunity for a women's track team, tried to run on the men's track team, and the federal judge said, well, we like athletic character in our boys, but we don't need that kind of character in our girls. Of course, as the mother of a daughter, that curls my toes, but it was that decision that actually led to the passage of Title IX. At no point in its 53-year history was the term sex, a very simple term in 1972, expanded or understood to mean gender identity or expression. And yet, under the Biden administration, that's exactly what happened.
Perfect. Well, thank you for that background. I think people really need to understand the basics and the crux of Title IX. And so in this particular, let me get back to showing this article that you wrote. So in this, you're talking about the Dear Colleague letter from the Education Department. For the record, our state superintendent of education, Tony Sanders, has already said that they are disregarding this, that, quote, it doesn't have the force of law. I think that, again, people need to look at your article in full. I've pulled this particular quote from it, but why don't you give us some context and kind of delve into now where we are with protecting Title IX and what may be happening in some of our states as some policymakers and people in positions of power say they're going to disregard it.
Yeah, so this is really a rectification of what we saw under the previous administration. Remember, the Biden administration, one of the first executive orders, and you all can look this up online, Executive Order 13988, was President Biden's directive to every federal agency head, and everything from HHS to DOJ to HUD to Department of Education, to take any federal statute that had the word sex in it, to expand it to include gender identity or expression. That, of course, included the Department of Education and Title IX, which again was the sort of crowning achievement of the women's movement. And it really made education possible for any woman who is listening in on this call today. President Trump has tried to rewind the clock. Now, it takes place generally in a couple of different stages. This executive order is really his opening salvo. It is his recognition that he is going to put all stakeholders on notice, any recipient of federal funding, that if they violate Title IX's directive on male and female, and they continue to pursue a trans inclusive agenda or gender neutral bathrooms, they are putting their federal funding at risk. The executive order was the first step. The second step was this Dear Colleague letter. And that is now coming from the Department of Education, who is initiating the rulemaking process. And it's their opportunity to put everyone on notice that, yes, if you file a Title IX civil rights complaint, it will not be a civil rights complaint where they fine for a trans identified male. But if there is an incident of discrimination, they will fine for a biological female. That's important for everyone on this call to understand, because the tide has changed. Now, if your daughter or your granddaughter or your niece is being divested of a slot on an athletics team, if she is finding herself having to change in a locker room with a biological boy, these are grounds for a federal civil rights complaint under Title IX. So what the Dear Colleague letter does is put them on notice of how the federal government is going to be interpreting it. It also indicates, and this is important, for the states who refuse to follow federal law and the president's guidance, they are risking their federal appropriations. Maine, for example, and I've written about this recently, Governor Janet Mills of Maine has dug her heels in, and she has said, we are going to follow state law, contrary state law. That's the Maine Human Rights Act. And she has just put $250 million essentially in the eyesights of the Department of Education. The way spending law works is like this. For individuals to get federal funding of any sort, and that's under Title VI of the Civil Rights Act, Title IV, Title IX, it works in the nature of a contract between the federal government and the recipient states. Once you break that contract by refusing to follow what it says about male and female, for example, you immediately imperil all of that federal funding. We're going to see, I believe, a very ugly knockdown drag out between Governor Mills and the Department of Education, but it is certainly coming. As an analog, we've just seen Columbia University divested of millions of dollars for their failure to follow another spending clause law, Title VI of the Civil Rights Act, by the way, also enforced by the Department of Education. This administration means business. It is going to take away federal funding, and it's going to do it as soon as it recognizes that these states and these school districts are in violation of federal law.
And we are here for it, Sarah. If there is an administration that's committed to getting rid of all of this anti-constitution, anti-liberty, anti-protection, anti-child, again, just activism and all of these terrible policies, it's the Trump administration. They are clearly on board and committed, and we've watched people who have been champions and advocates these last 4 years are now in the administration. And so there are some really good people that are doing very good work. I'm proud to know several of them, as I'm sure you do as well. So we're grateful for the work. And actually, Carrie is saying thanks for the work you do, Sarah, SPP, Sarah Parshall Perry. So yes, thank you, Sarah, for the work that you do. So let's go back to our slide deck here. So this quote is really important because there is this, I think, confusion between Title VII and Title IX. And I can tell you in the state of Illinois, and we'll kind of touch on this perhaps later in the conversation, Title IX in Title VII. So in our human rights, quote, guidance in the state of Illinois, I know that schools are using this to validate boys and girls spaces and effectively violating Title IX. And they mention Bostock. They mention that in their guidance sort of interpretation of the Human Rights Act permitting gender identity. So why don't we kind of delve into Title VII, the Bostock versus Title IX? And this is such an important quote in your piece. This position is legally untenable and has harmed women in the context of gender identity. So why don't we delve into the two different titles and the implications of each?
So this is interesting, and it's really a great point, Shannon, because Title VII and the Bostock versus Clayton County decision in 2020 really opened a Pandora's box, because the holding in that case was if an individual discriminates on the basis of transgender status or sexual orientation, that is necessarily discrimination on the basis of sex. And that's something that's prohibited by Title VII of the Civil Rights Act, which only covers employment, and it does not have
which was the
anything
Hobby Lobby case, right? It was the
Bingo.
Hobby Lobby case. And so that has to do with employment
Correct.
versus Title IX. So let's separate the two a bit then.
Correct. And then here's what I think is really important for the viewers and the listeners to know. At no point did Justice Neil Gorsuch, who wrote that opinion, say that gender identity or transgender status is the same as sex. But because of the wording in Title VII, which prohibits so much as 1% of consideration of an individual's underlying sex as prohibited under the statute, what he said was, biological sex is the starting point. A lot of liberals miss that when they read the opinion. He said, we begin with the understanding that Congress intended male and female as the biological definition of sex. But here's how he got to transgender status and sexual orientation. He said these two necessarily rely on underlying biological sex. And he basically said, if we tolerate a woman dressing like a woman, but not a man dressing like a woman, we are discriminating against him because of his underlying sex. He discussed attitudes and behaviors. A lot of attorneys who are textualists think he got it wrong, as I do. But no point did he ever provide a legal rationale for the expansion of sex to include gender identity, and especially so in Title IX. In fact, in the opinion, he said, we are not talking about locker rooms, pronouns, or dress codes, or anything of the kind, as if he was explicitly saying, we know how you guys are going to read this, but leave Title IX out of it. But that did not matter for the previous administration. They've used that case up, down, and sideways to be able to expand so-called transgender rights in every aspect of American life. Unfortunately, that's a legally untenable position. And in fact, it's the one Governor Janet Mills is relying on in the state of Maine, because Maine, just like Illinois, has a Human Rights Act that prevents discrimination in education on the basis of gender identity or expression. She's welcome to follow state law. She can follow the Illinois Human Rights Act, but she's contracted with the federal government. At no point did she have to take federal money. She took $250 million for the federal government. She's welcome to follow state law, but then she has to open up her pocketbook. And this is what the Trump administration is holding these governors accountable to.
For sure. And J.B. Pritzker is doing the same thing with all of his state agencies, where they're basically calling the bluff. Right? They're basically saying, no, we still think we're going to get the federal funding, even if we don't respect Title IX or any of the executive orders. And that's going to be, I think, a big mistake. And Maine is the case study in this. This is like the crystal ball for all these blue governors, where the bluff is being called. And if anybody's going to step up to it and smack it down, it's absolutely going to be the Trump administration. So J.B. Pritzker has told Tony Sanders, our state superintendent of education, if you're just coming on now, he has already said that they're going to ignore these executive orders, and they're ignoring Title IX. And so they have asked through the Department of Education, through the State Board of Education here in Illinois, for $2.25 billion with a B dollars from the federal government. That's crazy money. The total budget for Illinois 2026 is 11.4 billion. So it's a lot of money that they're going to want to rely on. And we know that JB Pritzker is going to want to expect that money. And guess what? It's going to get real uncomfortable when they start seeing that the Trump administration is pulling the plug on that. So heads up, everybody. This is a big deal. And so Maine is our case study in this.
Yeah, and I will say, Shannon, there is an understandable skepticism, right, calling the bluff of any administration, because believe it or not, in its 53-year history, no presidential administration, no Department of Education has ever revoked federal funding for violating Title IX. Now, we can't speculate as to why that is. It's probably a lot of effort to go through the legal ramblings and try to get this through the court system. But generally what happens in these complaints, and having served at the Civil Rights Office in Washington here at Department of Education, is that these go through a process called informal dispute resolution. So the school gets together with the complainant, and they get together with the Department of Education, and they try to work out a settlement to basically say, okay, you get your own, for example, private bathroom, or you get a chance to try out for another team. That is normally how the process goes. But this Department of Education is pulling absolutely no punches. As I said, they are going straight for the jugular in this when it goes to the federal funding question. And quite frankly, what I believe is going to happen is that this is going to be a real missive to recalcitrant state governors like Governor Pritzker, like Governor Mills, who have refused to follow the federal directives because, again, the contract with the federal government is entirely voluntary. But once you get involved with the federal contract, you have to hold up your end of the bargain. And the Trump administration has said, our terms are this: you protect males and females, not trans identified students.
Yeah, and I love how these governors are so snarky. That Maine governor to President Trump's face said, "See you in court," and he said, "Yeah, I will. It should be pretty easy." So they're digging their heels in, and they're so snarky about it. And she is a woman, just the audacity. It's such a shame, but I'm glad to see that people like you are going to be able to empower people to understand the nuances of this. It's really very important. So Title VII versus Title IX, you've kind of covered that. They are not blended together. They are two totally separate case precedents. Gender identity is in the Bostock in Title VII for employment. It is not incorporated into protections under Title IX. I really welcome anybody who's listening to this in Illinois or not to share this with anybody they know who works in courts as an attorney or as a judge, because you and I know, Sarah, we've talked about this in panels before where we've heard people say judges even in our court system have been basically given really bad information or guidance or education on even some of this case law. And so you can have some of these lower court judges who think that Title IX does incorporate gender identity, and it doesn't. And so I think that lawyers and judges really have to be in the know on this because they've been indoctrinated to believe the wrong thing. So share this with your friends, your colleagues who are working as attorneys or judges, because they need this information and background too, not just parents or everyday citizens. So this is an important distinction. Again, all of Sarah's articles are linked. So we will share these after we wrap up here. But again, Illinois is using this guidance, just like Maine is, because of the gender identity being incorporated into, quote, human rights in statute. But you made a very good point on Twitter that those state laws do not supersede the federal protections.
Correct.
So you cannot overrule the federal protections, particularly when states like Illinois and basically all of its agencies are taking federal funding.
Yeah.
So that is the checks and balances.
And I will say, this is an interesting situation because the expansion of Title IX to include gender identity or gender expression isn't just boys and girls sports. It's not just boys and girls bathrooms. It's also seeped into some of these ancillary school policies. And you guys, no doubt, in Illinois are experiencing this firsthand. For example, confidentiality policies on a minor's gender identity. Here's the problem with the Biden regulation. The Biden regulation said if you don't use a student's preferred pronouns, that would be submitting them to more than what is called de minimis harm. And that's a violation of Title IX. Well, if you're using preferred preferred pronouns and preferred names at a school, and you're not telling the parents, then we go into the question of, do parents have a constitutional right to know how their children are identifying? So
Mhm.
Title IX's expansion impacts gender confidentiality procedures and policies at these minor schools. And by the way, I know they're in Illinois. 12 million
Mhm.
American students are attending schools that have these gender secrecy policies, but it
Yep.
also affects curriculum. And believe it or not, we just saw a case being taken up by the Supreme Court. Its oral arguments are scheduled for April 22nd. Mahmood versus McKnight. This is a multi-faith coalition of parents who have sued the Montgomery County school districts. They come from all different walks of faith: Muslim, Orthodox, Christian, Jewish, and they've all said that teaching our children gender identity curriculum when they are 5, 6, and 7 years old is a violation of our parental rights and our
Mhm.
right to bring our children up in the faith that we indicate is important, that indicates and teaches male and female are distinct and never the twain shall meet. So we've seen this trickle down again, not just into facilities access, not just into sports, but now in preferred pronouns, hidden gender identity from custodial parents, and now what we see in curriculums with younger and younger groups of individuals, minor children who are already in the formative phases of figuring out who they are, being told by teachers, well, your doctor or your parent might have been wrong on the day you were born about exactly what gender identity or sex you are.
It's just horrible, and this is really what makes me emotional and really sad, because this is such a vulnerable time, for children, very impressionable. And in the state of Illinois, Sarah, we have in K through 12 legislation standards for the national sex ed standards. So K through 12 districts across the state, if they teach comprehensive sexual education, they have to use the national sex ed standards, which were devised by woke, sex activists, basically, and they introduced the concepts of transgenderism as young as kindergarten. There are a lot of parents that are just now figuring this out. In one of the largest school districts in the state, Chicago Public Schools, hundreds of thousands of kids, they have adopted these standards. And so you're right, this is not hyperbole. This is actually happening in K through 12 classrooms funded by your tax dollars. So
Yeah.
I'm really glad you're able to speak to how this has many different implications beyond just the bathrooms. I think the bathroom thing and the sports, it's become a very tangible thing for parents to latch onto and to discuss. It's more of like an easier approach, I think, for people conversationally, because you can see that happening, you can speak to it. But to your point, it's very nuanced, and there are many different ways that this could be violated. So let's proceed with another one of the articles that you published this month. Sorry, Democrats, but Trump's two sexes executive order is constitutional. This was published in The Hill. Let's delve into this again, because gender identity, they will oftentimes, say, the immutability of it. So why don't we delve into that for people to understand that particular nuance of the two sexes?
Yeah, that's a great question. So this executive order was one of the first that he issued, and it was very simply recognizing a whole of government approach to interpreting sex as male and female. It really did delete for all intents and purposes that executive order I mentioned earlier, which was 13988 from the Biden administration, which said expand everything to include gender identity. This is now contracting it and saying, for the purposes of this administration, this is going to be our policy, whether it's a law enforced at HUD or DOJ or HHS or Department of Education. This is where we're headed. Now, what we hear a lot when we're considering questions of whether or not a law that regulates discrimination on the basis of sex or race, for example, is whether or not the underlying characteristic is what's called immutable. In other words, it is rendered by nothing more than accident of birth. in a famous case called Frontiero versus Richardson. That was exactly the language used by the court. The reason we want to protect individuals who are born with certain characteristics about nothing, they can do anything, right? Whether that's national origin or ethnicity, whether it's race, whether it's sex, is that we want individuals who can do nothing about their own identities to make sure they are fully protected under the law. That
Mhm.
question of immutability came up in the now, I think, marquee case of the Supreme Court term, United States versus Scrimetti. Remember, the question here is whether or not state bans on so-called gender affirming care for minor children are constitutional. This is a case coming out of Tennessee. I would argue they are constitutional. I've actually written another legal memo on the constitutionality of these laws, but that question came up distinctly. Is this an underlying immutable characteristic? Is transgenderism the same as sex? And even the transgender attorney Chase Strangio, who was arguing on behalf of the ACLU in the case, had to admit on questioning from Justice Alito that no, gender identity, gender expression, transgender status are not immutable. Why? Because as we know, Shannon, you can't separate the underlying biological reality of who we are and how we are hardwired when we are born. So immutability for that standard, when it comes to sex, is a heightened level of scrutiny. If a law at issue is being questioned, if it's being challenged under the 14th Amendment's Equal Protection Clause, one of the characteristics the court will look at is there an immutable characteristic involved? So, of course, that played significantly into the US versus Scrimetti oral arguments. But if a case is based on some regulation of sex, it is subjected to heightened judicial review. In other words,
Mm.
the state has a higher bar to prove that that regulation of conduct is constitutional. The attorneys for the ACLU, for the Department of Justice under President Biden, were trying to argue that transgenderism should also be subject to a heightened constitutional review. But to my mind's ear, there were no buying it on the Supreme Court oral arguments. And that is going to be something going forward that's going to foreclose a lot of those constitutional issues when states regulate based on these particular arenas. If, for example, a state like Illinois changes course and said, we're going to modify our Human Rights Act and we are eliminating gender identity within the concept of state law, and we're back to biological distinctions of male and female. My guess, understanding that we're still waiting on an issuance of opinion in the US versus Scrimetti case, is that the Supreme Court is going to provide them the ability to do just that. Sex and
So an
transgender
off
status,
ramp,
an
basically, an
off
off
ramp.
ramp from all of this.
That's
Got it.
exactly it. And remember, that's a constitutional question. But then we have the statutory questions that you and I have been talking about, Title VII and Title IX, the standard for which judges and justices have to review statutes for their legality under federal statutory law is slightly weaker than it is under federal constitutional law. And while they are close analogs of one another, they're simply going to look at the text of the statute and what the drafters meant at the time it was drafted. Well, in 1964 and in 1972, no one can argue with a straight face that sex also meant transgender status.
That's brilliant. And that is a very, very important distinction for lay people, everyday citizens to know. And I still think, again, a lot of lawyers and judges are still figuring this all out because, to your point, at the Supreme Court level, this is all being ironed out in real time. So it's sort of exciting from a legal standpoint, but also it creates some chaos in, what I would call like boots on the ground level. So this is very helpful for people. Somebody asked a question about House Bill 2827. That's the attack on homeschool here in Illinois. I'll end with a wrap up on that, but hang tight on that. I know that we've got more than 22,000 witness slips opposing that attack on homeschool. So hang tight. We'll cover that at the end. I'll give you a little bit of update on that. So going through some more, again, into the implications of these executive orders. So in the American Conservative, you and Paul Larkin published last month this article, Trump's transgender orders are well within executive authority. So kind of coming off what you were talking about earlier with the Scrimetti case, I thought it was very interesting that this kind of taps into whether or not parents have the right to medicalize their children, which with all that we now know with quote gender affirming care, which I would call careless, it is not care. The things we now have uncovered via WPATH whistleblowing, medical doctors like Ethan Heim and people who have worked in the pediatric centers where they're doing the medicalization with gender affirming care, much of which is also covered by Medicaid, unfortunately, even in Illinois. Is that going to fall under the protection of parental rights? So you kind of delve into this. Why don't you walk us through some of your insight here?
Yeah, great. That's a great distinction, Shannon. And you see how the gender identity hydra just continues to grow more permutations and more limbs. And we're seeing, obviously, gender identity, not just in what you and I have talked about, employment and in education, but also within the concept of parental rights. And generally, the 14th Amendment parental right, and we're probably all familiar with it. There's a general duty to direct the care, upbringing, and education of one's minor child. That dates back to 1923 in a case called Meyer versus Nebraska. The last time the Supreme Court weighed in on a parental rights issue was in the year 2000 in a case called Troxel versus Granville. So it's been 25 years since the court has ever weighed in on the parental rights issue. But it stems from that 14th Amendment consideration. On the one side, we see the 14th Amendment implicated because parents are suing many of these schools who have, again, gender secrecy policies in place. They have a right to direct the care and upbringing of their minor children. And that essentially, and more now than ever, would go to the question of how a child forms and expresses their identity. I can't think of something more fundamental to the question of where the parental right starts and stops. On the other hand, we see people who are gender identity advocates who are trying to expand gender medicalization, arguing that it's their right to direct the medical care of their children. I wrote, as you know, Shannon, another legal memorandum on this, specifically saying at no point has any federal court held that that right includes access to experimental, irreversible surgeries, hormones, or castrating agents. In fact, the federal courts that have weighed in on that level of medical care have always considered it a general level of medical care. And in fact, in a case that was authored by Justice Ruth Bader Ginsburg, who always sided with the liberals while she was at the Supreme Court, during her time in the DC Circuit Court of Appeals, actually authored an opinion in which a father had sought experimental treatment for his teenage daughter who was on life support. And they found that he did not have a constitutional right to get experimental care. That question of whether or not doctors are in the better position to know exactly how to best treat a minor child is one that came up in that case in the late 1980s. And it is definitely one that is going to be certainly a consideration for the Supreme Court as well. But on one side, you have a right to know how your child identifies at school. You have standing to be able to say, you can't socially transition my child behind my back. And on the other side, the Supreme Court is very likely to say, and yes, you have the right to direct care, upbringing, education, and medical welfare, but not when it includes things that are completely experimental and unproven.
That there's a lot that you just covered there, but it is so very important because the woke crowd, the pro mutilation and sterilization of children crowd will always say, well, it is that parents' right? They try and throw this very strong issue of parental rights that has had so much grassroots fire behind it these last several years. They're trying to weaponize that in this particular instance. And it looks like it's failing at as you said, that no federal or Supreme Court has ever held that access to experimental, contested, or unproven medical inventions is constitutionally guaranteed. That's very, very important. So thank you for walking us through that real quickly. I think this is like our most watched live ever. We've got thousands of people watching across all of our platforms. So thanks to everybody who's tuning in. I knew that this was going to be a really, really important conversation, Sarah. So again, we're so grateful that you're walking us through this. I know parents throughout Illinois and probably many others are really appreciative of this insight. So we'll keep going here. So this was published via the Heritage Foundation, of which you are a senior legal fellow. Public school gender policies that exclude parents are unconstitutional. Walk us through what you and Thomas Jipping have outlined here and some of the takeaways of this particular write-up.
Yeah, this for me, I think, is a real passion project because still having two children, my oldest is a sophomore in college, but still having two children, an 18-year-old and an almost 16-year-old in high schools, I recognize, as do everybody on this call, exactly how important it is to identify and ascertain what's going on in your child's life, particularly now. This is not an era for backseat parenting. It is really an era for being front and center on a lot of these issues. But we were seeing sort of this precipitous increase in school districts across the country. It's more than 1,400 school districts, more than 12 million school students in any program from California to New York are now in schools that have explicit policies related to gender confidentiality. And they've said on a student say so, if they think their parent is going to be unsupportive, that they can have their preferred name, their preferred pronouns, their preferred sports team, their preferred bathrooms, all hidden from their custodial parents. Now, if you had told me 26 or 27 years ago when I had started practice that this is what I would be fighting in the public school system, I would have told you were absolutely crazy. And yet here's where we are in this cultural moment.
Such a shame.
That's exactly it. So we talked about this 14th Amendment generalized parental right dating all the way back to Meyer versus Nebraska. And what my colleague and I recognized was this trend in federal lawsuits through all of the federal circuits in these parents, these desperate parents saying, my child was sent down the path of socially transitioning. And obviously social transition meaning you use the name, the clothing, the facility use, the pronouns that this minor child wants. And studies show that more than 60% of minor children who start down the path toward social transition and begin to identify as the opposite sex ultimately go on to seek medicalization. And that is cross-sex hormones, puberty blockers, chemical castration agents, and then, God forbid, in many of these circumstances, things like double mastectomies for healthy adolescent girls, 30% of which, by the way, have either diagnosed or undiagnosed autism spectrum disorder. In no other context do we give an individual's sense of internal distress, whether that's anorexia or bulimia or ADHD or bipolar disorder, the tools to foment and include and expand that internal distress, except when it comes to gender identity. And in this respect, schools and gender clinic doctors are complicit in taking this idea of this temporary distress, which we know, Shannon, 80 to 90%, if kids are left alone, are going to make peace with their natal sex. Listen, puberty is not fun for any of us, okay? I don't think there's anybody on this call who would raise a hand and say, man, middle school was awesome. Every one of us was uncomfortable in our bodies and they were changing. We wanted to fit in. We didn't want to be different, but we wanted to have an identity all our own. And so we have seen this explosive rise in individuals who are Gen Xers, the youngest generation, who now outpace every other generation for the largest number of cohorts who identify as being gender dysphoric or transgender in their status. That's a full 30% of Gen Zers. That's horrifying. And part of the reason we see this is because schools who facilitate these gender secrecy policies pit parents against their children and reinforce the fact that parents are not to be trusted on issues like this. So the 14th Amendment, as it protects parental rights, some federal courts have already begun to weigh in and say there can be no more fundamental expression of the parental right than to know who your child is representing themselves to be at school.
Right.
If my son asks for an aspirin, I have to get a phone call from the school nurse. If my daughter wants to go to New York on a field trip, which she just did for the day at her school, I had to fill out a panoply of paperwork to get her on the
Mhm.
bus safely there and home. But in no other aspect do we permit unfettered access to our children without any governor switches that we do when the notion of gender identity arises. Now, let me also say for individuals who are watching today, take a look at your school policies. Ask questions. Go to your school administrators. Ask them about a minor child's gender identity and what the policy is about informing parents. Many of these particular school districts and local schools are professing it's a violation of FERPA, federal privacy law, again managed through the Department of Education, to essentially unmask or uncloset these children in their gender identity or expression. Let me clarify something for you all. FERPA, which is the Family Education Rights and Privacy Act, is a right held by the parents until the child gets to be the age of 18. So for school districts who are saying FERPA prevents us from letting you know about a child's minor gender identity, you can confidently remind them that that is a misapplication and total misunderstanding of
Mm.
FERPA start to finish. Not until college do these children get their own privacy right. And that's because the Supreme Court, for the better part of 60 years, has recognized something called the diminished capacity of children, whether it be in death penalty cases and the actual penalty that's meted out, whether it be in the regulation of, for example, harmful content like pornography or cigarettes. We don't allow children access to anything like signing contracts, registering for the draft, buying alcohol, accessing cigarettes. And yet, within the notion of gender identity, we are suddenly allowing 12, 13, 14-year-olds to act as if they know the best what is ultimately the best outcome for their lives, when in fact, as anyone who has parented a child knows, they are very often under the misapprehension of what they want to be down the road and who they are as people. It's our job as parents to help them shape that. The federal courts are beginning to weigh in, and all of them are recognizing that the fundamental parental right is implicated by these gender confidentiality policies. In fact, even as of today's webinar, there were two cases previously pending at the Supreme Court. The denial for cert, the petition for review was dismissed in both of those cases, but another one has automatically taken its place. Before too much longer, the Supreme Court is going to have to weigh in and going to clarify that these school confidentiality policies are patently unconstitutional. A case is going up from the 11th Circuit, and a case has just been filed coming out of the First Circuit. So before too much longer, and I wouldn't be surprised if it's as soon as next Supreme Court term, starting in October, we're going to see these issues taken up head on.
Thank goodness. It's just long overdue, and I've talked to too many families in Illinois and beyond who have been dealing with the trauma of having the school separate their children from their parents. That's what this is. It's dividing the home, it's dividing the family, and it has resulted in significant traumas for friends of mine and for people that we genuinely want to empower here in the state as people figure all of this out, and learn what their rights are. That's a really big deal. A lot of parents are so overwhelmed. They may have a child who is confused, who's dealing with some struggles, on top of not knowing where to turn, and oftentimes getting bad directives from the school or the counselor or even doctors. So they end up being just so overwhelmed, and my heart breaks for them. But I'm grateful that voices like yours and organizations like ours are sort of trying to stand in the gap and help educate people on the reality to this. I'll get into this a little bit later, but in Illinois, this is happening. And so when we post the blog with this recap, I'm going to show people what actual districts have published, and also the gender support plans are what they call them, that they use, that goes in the student's file. And parent times are often totally unaware.
Yeah.
Maybe you have a counselor who is perhaps steadfast and informs parents, but schools are being directed to keep it secret if the child says, I don't know if my parents are going to like this. So this is happening in real time, and I'll post some of the school districts that are engaged in this right now. So I'm glad that this is being taken up in the federal courts. We need it. We need these protections for families. My friend January Littlejohn was a guest at the joint address by President Trump recently, and I was so happy for her to have come full circle. She, her family, her daughter were in the thick of this hell, and they have emerged. And finally, I think there's some vindication now with President Trump's commitment to see parental rights respected, and to see that what happened to January and her family doesn't happen again. So my heart breaks for families, but I think there is some hope, right? We have to have hope that this will be eventually ended, all of this insanity. And so coming back to Illinois, we know that through the Human Rights Act and their guidance that they have issued, that they are violating Title IX. And it's a shame. I can tell you that in Illinois currently, Illinois is all in on the woke checklist. So I've put here the bullet points of what families and students and educators, not all educators are in on this either, but they are worried of being sued. So they toe the line. But right now, Illinois allows males into female bathrooms, locker rooms at school. They keep gender documents and trans identities secret from parents at school. They permit boys to play on girls' sports. Illinois currently exposes kids to trans concepts in K through 12 classrooms if they adopt radical comprehensive sexual education. Chicago Public Schools has. We've done reports every year annually for the last few years showing which schools that we've figured out via Freedom of Information Act request, which schools have adopted it. They tend to be very covert about implementing it. And so this is happening. They're being exposed to these radical concepts from a very young age. It's being normalized. And currently, Illinois is disregarding federal executive orders. So they have checked all the bullets on the woke checklist, and it's a shame. But this is very helpful for parents. And I think that many people are asking the question, I know I am as an advocate leader here in Illinois, what is the best pathway, Sarah, to ensure legal protections in Illinois and blue states? You could do Title IX complaints, sue your school districts, sue the state, file civil rights complaints, all the above. What do you think is the best pathway currently for parents in Illinois?
Yeah, first of all, I think you go forward and you ask the questions, right? You've got to be, again, an active parent in this landscape and where we are culturally. You have the right under federal statutory law to examine your child's curriculum. You have the right under federal statutory law to examine your child's record. You have constitutional law at your back when it comes to your right to know about your minor child's gender identity. I would ask the questions and I would get online and do your research about exactly where your school stands on a lot of these issues, whether that's women's sports, whether it's gender confidentiality policies, whether it is curricular inclusions for gender identity and transgender status. Make sure that you are fully armed with the information that you have. The Department of Education's Office for Civil Rights complaint process is, to my mind, an underutilized weapon of mass destruction. It is very easy to file a federal civil rights complaint. You can do it in one form, right online, and simply state what's happening. This is now an era where this Department of Education, as we've already seen with Columbia University, as we're about to see with Maine, is going to pull the federal purse strings shut for schools, school districts, and states that refuse to follow federal law. The Department of Education under the Trump administration, their philosophy, their interpretation, their application of federal law governs whatever these states and school districts say. And I know it's really a Hobson's choice for local school districts who understand that they've got the power of the state governor's house and J.B. Pritzker at their back, and at their front they have the federal Department of Education saying, well, that interpretation is wrong. It really puts them in an untenable position. So your best opportunity is, first of all, gain all the knowledge that you can about any policy within your school related to gender identity among those I've just listed. Second of all, file federal civil rights complaints. I will send to Shannon after this the link specifically at the U.S. Department of Education website. Very simple form. You can fill it out online, and it doesn't have to be a parent. It doesn't have to be an educator themselves. It could be someone with firsthand knowledge. It could be a family member or a friend who has reason to believe that this is happening. Every complaint has to be reviewed by the Federal Department of Education. You all have a Federal Department of Education regional office in Chicago. There are 12 regional offices. And so once you file with the Federal Department of Education, it will be farmed to the Chicago Department of Education Civil Rights Office, and they will be duty bound under guidance from the federal government to interpret and apply Title IX and parental rights is exactly how the federal government and President Trump have interpreted them, which is to say parents have rights, biological male and female distinctions matter, and federal privacy law allows you an examination and a right to be present in your child's education. Those are the steps I would take going forward.
Beautiful. And I can tell everybody listening, if you are a parent, an educator, a student, whoever you are, if you need some help with filing a complaint, Awake Illinois, we actually have a really big announcement coming out tomorrow on this topic. So more to come tomorrow. Stay tuned for that. But we know what it takes to file a complaint. And so if you need any help, or if you need Awake Illinois to file one on your behalf, we can do that. But to your point, you look at organizations like Parents Defending Education. They have done a phenomenal job of filing these complaints with the Department of Education, and they've been very successful, at the very least, in bringing attention to what is actually happening. And then parents start to figure this out, and they learn very quickly that they do have rights and protections that can be defended. And so Awake Illinois is prepared to help anybody in the state of Illinois with that, whether it is Title IX or parental rights or these gender support plans, et cetera. So please reach out to us if you need any help with that. But stay tuned tomorrow. There's going to be a pretty big announcement from Awake Illinois on that topic. So thank you for walking us through that and the pathway. And Sarah, the question that was asked earlier by Can We Be Done Yet Here? Do witness slips for HB 2827 need to be done again since they are messing with the dates again? So this is pertaining to a radical law that is trying to be put forth in our General Assembly that would be an attack on homeschool and education freedom. It would require homeschool families to register with government, along with private schools to register with government. There are a lot of really terrible, let me go back to that. There are a lot of really terrible implications here because it would be government overreach. And we know that in the state of Illinois, public school enrollment is on swift decline. They are all in on wokeism in the classroom, radical sex ed, and we know that homeschool and education freedom is a big competitor to that. And so we've been fighting this for several weeks, more than 22,000 witness slips opposing as of about an hour and a half ago. And yes, the date may be pushed back from this Wednesday to a week from this Wednesday, making it March 19th. And so then the witness slip count will reset to 0. This is totally intentional, but we have receipts, we have snapshots, and we're going to ask all 22,000 of you and more to continue filing witness slips if they don't pull this bill. We would like for them to. We do not want governments coming into our home, knocking on our doors and asking what we're teaching our children. This is the ultimate form of liberty, and it ought to be protected. So thanks to all of you who have been, submitting those witness slips, telling everybody about what's happening. Sarah Parshall Perry, Senior Legal Fellow with the Heritage Foundation. Any closing remarks for our listeners? Again, I think this is our most watched live stream. You've given people such wonderful information. You are a mother of 3, a brilliant mind on all of this legalese. What's your closing remark for everybody that's watched here today?
I think my closing remark is to be encouraged, right? So it seems to be a bit of a dire environment right now because of what we're seeing in terms of these particular recalcitrant school districts or the blue state governors. But be encouraged because where I sit in my perch in Washington, we are seeing some tremendous developments. And this is a president who is not going only to champion parents' rights and the biological reality of male and female distinctions, educational quality, but he is also someone who, through the Department of Education, has now posted on the Department of Education website the value of school choice and home schooling. This is the first time the federal Department of Education has recognized explicitly that there is value to alternative education options. So be encouraged. Really, the wind is at your back, but get all the information that you can. Use your rights under federal statutory law. Ask the questions, make the examinations, sit in on your child's classroom, and just know it's going to get a little harder before it gets worse, but we can definitely see the end in sight.
Thank you so much, Sarah. And again, to all of you who have watched, please share this. Sarah's insight is so important to, empower all of us in our families and in our schools and beyond. So we will be sharing this recap with all the links to the slides. All the slides will be in the blog post, and we'll post them to our social media so that you can get all of the comprehensive understanding based on Sarah's awesome publications and her insights. So God bless you, Sarah, and thank you to all of you who joined. Please share this and have a great rest of your Tuesday. Thank you, everybody. Take care.
I really hope you enjoyed it. We had a ball making it. Thank you very much.